Today I have to my right the Honourable Justice Laura Stein, a Judge of the Supreme Court. To my left is Penny Crozer, the State's Courts Administrator. To her left is Linda Abrams-South, the Executive Director of Corporate Services at the Courts Administration Authority. And behind me are Stacey Briggs, Acting Finance Manager, Courts Administration Authority, and Michelle Garaffa, the Senior Business Analyst, Courts Administration Authority.
Thank you, Minister. And you don't have an opening statement? No opening statement?
No opening statement,
No opening
Chair.
statement? Excellent. How about you, Member for Hyson?
No opening
I assume you're the
statement.
lead speaker?
Yes. Just a member of the committee, sir.
Just a humble member of the committee, then proceed to questions. Thank you.
Thanks very much, Chair. Attorney, Judge, and thanks all for joining. I'll turn first to page 126 of Budget Paper 4, Volume 1. And if I might flag a general interest that might sound more specifically in questions down the track in the interaction between particularly the Youth Court and its DCP and DHS related functions that are expressed in the data. But first in the general, there's a table at about point 6 on the page, workforce summary and FTEs as at 30 June. We don't see there the 24-25 FTE budget, but I understand that was 718 FTEs. The estimated result is 699. So of those 18 FTEs that were budgeted for but not retained over the last financial year, is there an explanation specifically for that?
Just to clarify the member for Hyson, we're looking at that the totals in that last table.
Yes.
The estimated result of FTEs being 699.1 as compared to...
As compared to 718, which was the budget for 24-25. We don't see that on the table.
Okay, so I don't have that in front of me, but
No,
I
and I don't either.
If it was 7, so your question essentially is the 18.9 FTEs difference. What's the why are there nearly 19 less than what we budgeted for?
If I'm right
as
about that figure, and
my advice is that the funding for some of those officers are primarily sheriff's officers within the courts, and that funding hasn't been needed because of some of the major cases, particularly in relation to Ironside, while those matters percolate their way through as they have to the High Court. But the funding for those, particularly sheriff's officers, has been carried over with an anticipation that particularly things like Ironside matters will find their way to fruition over the next year. So it's my advice is primarily sheriff's officers who were budgeted for in anticipation of the needs for Ironside cases. Clearly that hasn't happened to the extent that was anticipated with the High Court challenge and then the High Court challenge to the federal legislation, but it's been carried over so that, hopefully when we get a result from the High Court on the challenge to the legislation, they can be used now.
all right, and I think the only follow-on question from that is that we don't see 25-26 going to 718. We see it going all the way to 734.1. So is there some further uplift that's expected at some stage?
For things like Ironside.
for the same topic, or is that some other reason?
Yeah, my advice is, very similar reasons as the anticipated significant increase in activity once the Ironside trials start in full swing. We'll see a need for that extra staffing.
Right. And so, without, it's not a technical term, but does that mean that we can sort of think about 700 FTE or so as a sort of steady state, and 718 or 734 reflecting a kind of seasonal load that will then subside again?
My advice is, in effect, that's around about the case. The increased figures from the year before with the 18 more that was identified in the first question, the 34 more are anticipated to be needed because of the special circumstances, particularly with Ironside, and that's time-limited funding. But there will be things we can't anticipate that may, indubitably increase the need for these sorts of services in court. But it is not seasonal, because I think seasonal probably happens regularly. These are one-off unanticipated events that have had to have been accounted for.
If there's a comparator or corollary, we've heard it in other agencies. DCP stands out, for example, where the minister's sort of telegraphed as a virtue the employment of more people being self-evidently a sign of things being positive in the agency. We'd leave that for others to judge. I'm not asking the question, obviously, with a view to it being self-evidently negative or positive, but just for information, if they're FTEs, it might be helpful perhaps to advise the committee, if there is a seasonality to it, they're not specifically associated with a particular case or cases, but are these FTEs employed for any unusually short term? Is there something that might be anticipated in advance to say, well, they will actually come and go on present settings?
This might provide some help, I think. My advice is there are 15 new and ongoing FTEs for the ordinary operations of the courts that are budgeted for. There are 18 that are carried over that will be specifically attributed to both Ironside and the possibility of further trial in the Elsa-Wayne case.
Going one page further on, 127, and a table that's at about the same level of that next page, investing expenditure summary. Question about the Court of Appeal office accommodation, the first of those existing projects. Now, my recollection is that the 24-25 budget had estimated completion of that by June last year, and with a total project cost of 1.3 million. So two questions are, why has the project been delayed, and why the variance to project costs from last budget to this one?
My advice is that the funding in previous budgets that was provided for the Court of Appeal office accommodation has been completed, that there have been Treasury approvals for what has been in that budget line to be applied for other purposes. I'm informed that there was carryover approval of $328,000 to 25-26 for court modifications in the Sir Samuel Way building relating to multi-defendant trials. So it has been completed, but although it's still under that budget line, there has been approvals for carryover and reallocation of that funds for other purposes.
Right. And is there a way neatly to make sense of that 999,000 figure, therefore?
It's converted, investing, so it was.
It might be easiest if I take that on notice to provide a consolidated answer for you.
One more question in that table. Sam Way, Sir Samuel Way facade repairs is, has been a feature for some years. My recollection again is that, I'm not sure, it might appear here on the face of this table as well, that that was to be completed in June 25. We now see its estimated completion is June 27. I can't recall what previous project total costs were. I think 11.5 million's been around the mark for a while. I don't think that's changed. But with the 2-year delay on the project completion, is that then going to come at a greater cost? And then what's the reason for the delay?
I'm advised that it has taken longer than initially anticipated because of the nature of the building, the heritage status of the building and the construction materials in the building. I'm advised prototype works have been designed to verify the methodology that's going to be needed for that treatment of the facade of the building and to inform broader scopes of the work, but that work is underway. But yes, it has taken longer than anticipated because of the very nature of the building itself.
But no cost impact as a result of the 2-year delay?
Well, my advice is that they have to verify exactly how you can do these sorts of works on a unique building. So that work is underway, but that needs to play out.
Understand, and that explains the delay, but in terms of the cost, there's no shift in the project cost? There's been nothing that suggests that yet, but that doesn't mean that once more is known about how you remediate or do these sorts of repairs, that there may not be changes. So perish the thought of a comparison, but we heard from the government that the hydrogen plan was going to be 593 million, all the way until it wasn't, it's not. I'm not rushing to put this in that category. The budget's been set at 11.5. Ordinarily, one might think that just with the CPI and cost increase and all that stuff over time, that it might naturally end up costing more. But there's no particular reason why it's come in less than it would otherwise have been that accounts for the delay being able to be absorbed within the budget. No, as I said, my advice is that it is difficult work. It's taking longer than anticipated until we know for sure exactly how the works will be carried out on such a unique building. That
we'll know exactly what the cost will be. But yeah, that's why it's being done prudently and methodically.
All right. I get the delay, but again, we've got a very specific total project cost of 11,494,000. That hasn't changed despite the 2-year delay.
That has changed, and as I think Member Fyson, you pointed out, as projects mature and projects evolve, it's not only price that can change, but scope backwards and forwards can change as well. So you can obviously work towards a budget and vary what you do and how you do it to make it as well.
But I mean, the building's well known. The building suffers from concrete cancer, and the building and the heritage aspects, all that's well known. Is the minister then saying that, well, confident of the project cost, that's going to stay at 11.494 million, and they'll just have to cut their cloth to fix a bit of it?
No, not necessarily. How you stage what you do in what order, and the timeframes obviously can be looked at, but we're not even up to that stage yet. It is just the prototype design work to verify the methodology to properly assess the condition of the facade and what might happen.
All right. Well, but it might just leave one sort of anticipating that at some stage we're going to see a total project cost in a future budget that'll be a very different figure to that.
Well, you know what they say.
That you just call that a hypothetical at this stage.
Well, yes, the project's underway. We're verifying how it looks, but we'll see how it goes.
All right. I'll go to some performance indicators, and page 130, 131. Before I do, and this is a question that through you I've asked of the Chief Justice when he's been here, and I'd asked Justice Stein, just in the broadest separation of powers sense, is the court satisfied that it's sufficiently resourced in order to do the work that it needs to do?
Again, I'm advised that there is a budget. The Courts Administration Authority work within that budget as efficiently and effectively as possible to deliver the services that courts do.
On behalf of the committee, I thank the courts for the work that they do in the interests of all South Australians. Turning then to those performance indicators, and might I ask a question in the broad that the Attorney, I'd welcome if the Attorney wanted to reflect on this in respect of any particular aspect. But is this proposition good, that performance indicators are either generally or in specific circumstances a guide to where further investment is needed? But just hold that. I'll be more specific, and if the Attorney has anything to say about how much that's guiding where further investments of either capital or labour in the form of FTE are applied, then that would be interesting. If I turn then to first the criminal jurisdiction.
Which particular? We a page?
Well, bottom 130, we've got performance indicators starting.
Okay.
And we've got backlog indicators. Then we've got a whole series of backlog indicators that go over the page.
Yep.
And so I think I'll just go to the top of 131 in the District Court.
Yep.
You got that? So the percentage of lodgements pending completion that are greater than 12 months old, for a start, and this is one of those targets where the lower the figure, the better. And there's, I'm not sure if these are ROGS targets or targets that you've said or just need to be reminded, but there's significant variance anyway, more or less consistent variance from one year to the next between actual and target, estimated result and target, in more or less 4 times the number that are still pending. So the target for 24-25 was 10%, 24-25 estimated results 39%, and again you got this heroic target of 10%. Is there any, so I mean, is this the actual pattern that we can expect to see, or is there a realistic prospect of approximating the target?
Yeah, in terms of, and we've traversed this at, I think, most estimates.
Yeah.
And I think this will answer the statement/question you introduced this with. The targets that are set down are, as you indicated, they might be set by ROGS, the Report on Government Services. The targets are the same, I understand, for every jurisdiction. So the targets aren't changed to reflect differences that happen right across the states and territories. As I'm advised, the targets were set down in 2003, more than 20 years ago, reviewed in 2015, but without any substantial change. So probably the notion that variance from a target is indicative of where there's more investment needed probably isn't a particularly good indicator of where more investment's needed.
Okay.
Our targets that were set down more than 20 years ago and are exactly the same for every state and territory without any differences of how their court system works or the varying levels in the judiciary, probably aren't particularly useful. So I think in the question that was asked, are these targets that are merely ambitious without a hope of being met? Well, given that, in some cases, yes.
And it's a bit extracurricular, but given that we're talking about ROGS, is the attorney or the courts aware of a league table that has a star on it? Is there any jurisdiction that is actually remotely relating to these targets?
This target that we're talking about? My advice is in that 10% target, there is no state or territory for 2023, 2024 who's met it.
So is that a matter for attorneys?
Well, possibly. We could spend a lot of time, a lot of effort, a lot of resources, a lot of officials constantly reviewing targets, setting different targets in different states. I'm not certain that's the best use of limited resources.
All right. Well, if we've covered off on then the, sign for investment required and also an interpretation nationally of a ROGS figure that's 20 years down the track, does the attorney regard performance even remotely close to that target as being something desirable or part of policy consideration, or is that state of affairs okay, steady state, and that's right what the government's prepared to live with?
I think obviously you want your justice system to run as effectively and efficiently and as timely as possible.
Yeah.
Tending towards targets as low as 10% is obviously something to aim for, but as I said, the targets that were set down in 2003 that no jurisdiction meets, I don't think any jurisdiction would realistically say, well, we're not meeting those targets, something's fundamentally wrong, or we need huge investment in a particular area.
And I might include and not to single out the district court for particular focus here. That the whole table tells a story in a way. Magistrates' court figures are similarly at variance. You come to the youth court in a moment, but you just highlight that second figure for the district court, completion greater than 24 months old, has gotten quite significantly worse from year to year. So and here we've got, again, a ROGS target of 0, an actual result in 2023-24 at 11% against 0, which looks actually quite good compared to 24-25 at 17%. Is there a reason for that deterioration?
We have many Ironside matters that have started that are not progressing at the moment and that are quite old, waiting for decisions of high courts are, it's no coincidence that, there are these Ironside matters that have started, haven't been able to be finished, and there are matters that are getting towards a couple of years old. So it is Ironside that is largely, I'm advised, can be attributed to many of those. Yeah, so you start the prosecution, you have the evidentiary challenges that we saw to find our way through our Supreme Court, then to the High Court, changes of the law made at a Commonwealth level, those laws being challenged. So there has been significant delays in Ironside, particular prosecutions that have started that haven't been able to continue while those matters are being decided.
So if one's looking for Ironside impacts on our court system in South Australia, one can look at the FTE count and say, well, there's a lot that's in the pipeline, therefore we haven't employed everybody, and we're therefore at 699 versus 718, but we're projecting to go to 734. And at the same time, you can see that there's a big uplift in the non-completes after 24 months. That's also due to that workload. They would appear at first blush to be contradictory, but perhaps they reflect different parts of the pipeline.
I think that's correct, that the carryovers waiting for Ironside trials to start means that there are less, particularly sheriff's officers employed, but the flip side of that is there are matters that have started but are being put on hold, and while they're on hold, we don't need as many sheriff's officers. So yes, those lodgements pending greater than 24 months increasing because of Ironside also have the effect of the carryovers and not needing the staff as of yet.
Well, so, and on that, if let's assume that there is actually something more than a steady state in the offing. We've got a Criminal Justice Administrative Task Force, I think, doing some work. And to what extent is that work directed towards reducing backlogs, or is it, is that off the table?
No. The Criminal Justice Task Force has been doing some very good work coming up with proposals that will be put to government to, in part, increase the efficiency of our criminal justice system. And if they work, then they necessarily will have an effect on how things flow through and may have an effect on backlogs. But as I said, those over 24 months, that my advice is it's largely attributable to the delay in Ironside stuff.
Right. So, all right. Well, so the Criminal Justice Administrative Task Force might have.
If there's specifics on that task force, that's probably better to do in AGDs rather than
Okay.
courts. It's housed in hopefully we'll have some effect of some of the recommendations when they come and are reviewed on the function of the courts, but it's hosted within Attorney General's Department.
Happy to come back to it, and the attorney might remind me as well if there's more to say to advertise its good work in AGD. Happy to do so. Just while we're directed on the backlogs, I thought to mention it.
No, I won't remind you. I'll let you.
Yeah, I thought you might. So in terms of backlogs, to be clear, there's no new money, as far as I can tell, directed at reducing backlogs. We can talk more about the Administrative Task Force.
Well, if I can,
Sure.
Member Hyson, I don't think that's entirely correct to say there's no new money directed to reducing backlogs.
Right.
There has been significant investment in this budget,
Right.
Particularly for the DPP, and investment and Forensics SA, who do a lot of work in the criminal justice system, and in previous budgets and mid-year budget reviews, further money, particularly for DPP, for the courts as well, to reduce anticipated backlog from Ironside in particular. So there has been significant investment to reduce the backlog that is showing up in the figures, but can't be addressed yet because we haven't started those trials.
And as the attorney's already said, it may be that money is not likely to shift those data that are 20-odd year old ROG's data. Is there, as far as the government's concerned, is there anything else that then might contribute? If it's not money, is there some capacity via policy and reform and so on to address that? It's really an open question. Maybe the answer is, we keep on working every day. But anything on that front that might transform the situation via policy reforms?
Yeah, there certainly may be things, and you touched on it with the task force that's housed within AGDs, and we look forward to working our way through suggestions that they've made. That, is there something that's going to be absolutely transformative that will fundamentally change and have no backlogs? I doubt it very much. But certainly, the former Liberal government, the former Labor government have done things to try and address that, whether they be how guilty plea discounts work, a whole lot of things that both governments have put in place that have had some effect. But it is something we will obviously always strive for if there are sensible reforms that can be made that don't do anything to jeopardise community safety in particular. We are always open to them if it's going to create a more efficient criminal justice system.
Now, I flagged an interest in the youth court, and I'd just turn to that here at 131. And I might ask that you keep handy also the table at 136. 136.
Page 136?
Yes, 136 from, again, at about 0.6 on the page, performance indicators. Yep. That's under Program 2, Alternative Dispute Resolution Services, and there's two bold headings there, Family Conference and Care and Protection. And then over at the top of the following page, the activity indicators continue for Family Conference, Care and Protection. But just starting at 131 and the final line in the activity indicators table, which is about, therefore, halfway down the page. So the youth court had a projected number of finalisations for 24-25 of 4,000. Its estimated result was considerably in excess of that, at 4,631. And I know the Judge of the Youth Court's not here, but has the Youth Court and the Judge of the Youth Court in particular, conscious that the Judge of the Youth Court's now on the joint committee, has that court in particular raised any resourcing concern to government and to you, Attorney, in light of that workload?
My advice is these matters are finalisation numbers in relation to criminal matters before the youth court.
Yep.
Is my advice.
Yep.
That many of these relate to administrative breaches of bail that have seen an increase.
Yep.
I have regular meetings with the Judge of the Youth Court. I don't remember any requests being made that the criminal matters before the Youth Court required more resources, but my advice is many of the ones that are big, the reason for the increase are administrative breaches of bail matters that are heard but count as a stat for criminal finalisations.
Well, and if that's the case, then what's changed? Is that the result of
In terms of the factors driving that, I wouldn't have answers to those now. I can take them on notice and see if the youth court has a view or keeps statistics.
All right.
There might not be, but I'm happy to ask.
For the attorney's benefit, then, is it the case then that that might not be a demonstration of a dramatic uplift in breaches of bail per se, but rather a different means of dealing with those?
Yeah, it might be. It might also be, as I'm advised, a matter for police as well as to how these matters are detected and enforced and brought before the court as well. It could be reflective of.
But it's possible. It's a reflection of an increasing number of breaches of bail.
The detection of breaches of bail.
Yeah. Well, the number of breaches that the court's having to deal with and is dealing with. So we go from a projection of 4,000 to 4,631. The attorney says that's largely, if not wholly.
Well, substantially. I don't want to.
Yeah.
My advice is, that is one of the factors and explanations for the increase.
So a relatively large increase in the administrative burden of dealing with breaches of bail, and it sounds it's not seasonal or temporary, in that it sounds in a considerable change in the 25-26 projection, now to 4,500.
Yeah, and look, I don't have previous year's figures to compare before, but the actuals for 23-24, well, I'm just reading this, 4,226.
Yeah.
It may have been that the estimated was significantly below that, and structurally we come in above the estimated result. I'm happy to go away and take on notice.
Thanks.
And have a look. But certainly in terms of number of offenders, I'm off the top of my head, I think the Australian Bureau of Statistics youth offender rate sees South Australia as the lowest offenders per 100,000 of anywhere in the country. Only the ACT with a lower number than that. So it's clearly not more young people offending with the lowest youth offender rate of any state in the country.
And the attorney refers to it, the 23-24 actual, at least to go that far back, because here on the face of the table, that actual result of 4,226 is the attorney also telling the committee that that was largely the result of the same cause?
No, I don't know, is
okay.
the answer, and that's why I'm happy to take on notice and go on.
Suffice to say, though, that despite the 23-24 actual of 4,226, the projection was restored to 4,000. So it was perhaps regarded as an outlier that there was reason to think might reduce again. Whereas this year, we don't see it reverting to 4,000. We see it a tick back from what was a significant increase, but not so much. So is there, we might be just going around the same cause and effect, but is there anything to explain why the projection now might be regarded as less ambitious than what the projection was in 24-25?
Yeah, again, I'm happy to take that on notice and bring back a reply from the member.
Because the proposition that is sort of out there for the moment is that we've got this kind of, breach of bail crisis going on in the youth court. And if the youth court's sort of doing what it can to manage that increasing load and hasn't raised the need for more resources to deal with that load, then that might be as the result of a good administrative practice, but the volume itself seems to be sounding a warning just on the face of that line. I don't know if...
I'm happy to take that on notice.
The attorney's taking
I don't
that.
have the youth court people here with me.
All right. Well then, heading in, and the attorney, and I appreciate highlighting the difference between the youth court's work on the criminal side that we've just been talking about, and then on the alternative dispute resolution services side that's demonstrated there in the performance indicators at 136, 137. The maybe best demonstration of the workload of the youth court on the family conference side is the first line of that table at 137.
7.
That's activity indicators family
Yep.
conference. And you got that? So we see there that if we work from 23-24, the actual figure is 1901, 1,901. But the projection was that the projected result for 24-25 was less. The estimated result considerably higher. So a projection of 1,800 with an estimated result of 2,224, which seems to indicate the youth court's doing a lot of active work in that space, considerably more than the 24-25 projection. And we've heard a lot from on the DCP DHS side about reforms that will amp up family conferences for all the right reasons. But the projection for 25-26 reverts back to the 24-25 projection. So that doesn't seem to indicate any structural increase in those referrals, and in fact, given 24-25, would seem to indicate a substantial reduction for the year ahead. But is there any explanation for that? Does that sound elsewhere now?
Again, without the people from the youth court here to talk about how they set the projections. And I don't know. I'm just guessing one explanation might be they've got the same projection again, and if there's further trends that keep it towards what we've seen the estimated, they might change for the next year. I don't know what's gone into the formulation of the projections. But just to be clear too, this isn't child protection family conferences, which certainly have been spoken about and been the subject of a lot of discussion, I know, during recent legislation. These are in the criminal area. So these sorts of family conferences occur when a young person admits the commission of an offence within the meaning of the Young Offenders Act. Referrals are made to the conferencing unit by the South Australian Police and by the Youth Court, and family conferences are essentially a nulla stream or diversionary process that offer a restorative approach with victims given the opportunity to participate in the process as well. Having been fortunate to visit a couple of times the Youth Court here in Adelaide, and also regular meetings with the judge of the Youth Court, it is reported to me that the participants often find these quite valuable, particularly those on the other side, victims in relation to offences, find this quite a valuable outcome. And of course, anything we can do to lessen young people's coming into significant contact with the criminal justice system is a good thing for the prospects of later in their life still not coming into contact.
Yeah, and I just flag in case there was any doubt about it, I share those sentiments entirely. Would the attorney though? I've referred to this crossover of interest at DCP and DHS and reforms on the DCP side that the Youth Court has a keen interest in. So we're here doing a budget estimates process, and therefore including in scrutiny of the resources allocated to the youth court. First, perhaps I'll ask, is there some particular reason why it would be necessary to refer to advisors not here in relation to the youth court specifically? It's not a trick question, but
If you've got questions about matters, care and protection matters that the Department for Child Protection
Oh, yeah,
work
sure.
on, there is a very good possibility I'm not going to have much information at all on the
Sure.
drivers behind those sorts of
sure,
things.
I'm limiting myself to this aspect of the workload, the sort of thing that might find its way into the to the judge of the youth court or to the youth court, those responsible for it, including the administration authority generally, speaking up for resources for the youth court, the result of its many burdens, put it that way. Here we see a couple of indicators of a criminal burden.
Yeah, I'm not sure what the...
It hasn't sounded in any particular request for additional resources.
Yeah, as I said, I have regular meetings and I can't recall that we've had more family conferences or that that we're hearing more administrative breaches of bail, we need more resources. I don't recall that.
All right.
Rose.
Just to interrogate that line item then a little bit more,
So which one are we still on?
first line item on 137.
The family conferences?
Yep.
Yep.
Number of youths referred to family conference.
Yeah.
Just to be clear, they're not the 1,800 that is repeated as a projection is not that's not ROG's data. That's a actual thought through figure that's specific to the jurisdiction. And
That's my advice.
And it's been retained at. So,
Would be, ROG's data that are the same in every single jurisdiction, to have an absolute number, not a percentage, would
Yeah, of
be
course.
even more of even less utility given the different sizes in jurisdictions.
yeah, of course. So we're not dealing there with a with some ever fixed mark inappropriately stuck somewhere that can't be changed. In fact, we see the projections changing in that very table further on. But we've anyway stuck with the same projection. Does that give us a clue that there's anything unusual about that trajectory of growth of the number of youths referred to family conference over projection year on year?
Not necessarily, but again, I'm happy to take that on notice. It might be they've just merely carried it over and repeated it to wait to see if those figures continue, but what was in the mind when those were said, I'm going to have to take on notice.
All right. Well, I appreciate the attorney's willingness to take that on notice, and I won't ring that out, as it were, any further. Clearly, there's valuable information that might be provided, and I'd just flag a keen interest in it. And if I might just put one general observation in terms of the youth court facilities generally, has the government given consideration, even off its own bat, to the accommodation and adequacy of those facilities? I think it's well known that they've been unchanged now since Dunstan and King were both on a plaque over in Red Brick Building.
As I said, I've had the privilege and the benefit of being able to visit the youth court a couple of times, and I think it's fair to say, and I don't think this is limited just to the youth court, but in a world of unlimited resources, I think many levels of our court system would be grateful for new, improved accommodation. But it is a matter of resources and the functionality of how things are working. But certainly it has been raised with the youth court.
If I might just turn a couple of pages back to performance indicators. And on the way, perhaps to 135, subprogram 1.4 in the coroner.
Yep.
If there's time, I'll just address briefly some of the performance indicators in terms of civil jurisdiction, and then some more on the criminal side. But just conscious that time's getting away. Subprogram 1.4 coroner at page 135.
Yep.
The government's provided the extended funding for a third coroner. That came about subsequent to the last estimates in the mid-year budget review, as I recall. And so then we're seeing a sort of part-year reflection of that sort of set of circumstances, but without improvement in the backlog. That's, there's been a 1% improvement, I think, as I read it. Is that, and then the activity indicator, the final line on page 135 tells us that the projection for 24-25 was 3,200 coronial finalisations. The estimated result is 2,888, and the projection for 25-26 is a reduction actually in the 24-25 projection down to 3,000. So, despite therefore the funding for a permanent third coroner, we see simultaneously a reduction in the projection for coronial finalisations. Is there anything the Attorney would like to say to explain that? Or whether he'd like to or not, could the Attorney inform the committee about why that apparent reduction in performance is projected? And do we need a fourth coroner?
Yes, I think as the member for Hyson has pointed out, there had previously been 3 coroners. That there was time limited funding that I think both former governments of both former stripes had provided. That ran out.
Yeah.
For a period of time, there were 2 coroners. We could see that there was easily enough work for the 3 coroners, and I think after 6 months, as the member pointed out, in a mid-year budget review, reinstated that funding, and not just a time-limited funding as it had been before, but ongoing funding.
Yeah.
I'm aware that that there is, essentially catch up in terms of the work of the coroner that needs to happen. Why the projections have been set at those figures, again, I don't have the benefit of having someone from that jurisdiction here, but I'm happy to take on notice.
All right, thank you. There's one sort of rather important thing that I didn't get to on page 136. It's going back to the those questions a moment ago. At 136 performance indicators, the family conference and the care and protection headings, we see there what might be regarded as a drastic reduction in the number of, the percentage actually in this case, in this table, the percentage of family group conferences which result in valid agreements for care and protection of children. That's dropped, and we're even leaving targets aside, it's well under target, but even looking at actuals, the 23-24 actual was 91% of those family group conferences that resulted in valid agreements for care and protection of children. And that's down in 24-25 to an estimated result of 57%.
We have 1 minute, Attorney.
It's not quite halved, but it's a drastic reduction in valid outcomes.
Would have been down to,
45.
well, halved from the actual from 2003-4 would have been a lot lower than that, but
No, anyway.
The advice that I have is that referrals have significantly reduced, and I am advised that referrals to the conferencing unit received for family group conferencing are increasingly complex matters. So the combination of the referrals reducing and the complexity of the matters, I'm advised, is a contribute to that.
Okay. 10 seconds to spare. The allotted time having expired, I declare the examination of the Courts Administration Authority complete. And I'll sign that in a minute. And we'll now move on to the Attorney General's Department and State Records. The Attorney again, but presumably some new advisors. The estimate of payments is $155,240,000 for the Attorney General's Department. Administered items for the Attorney General's Department, $90,903,000. For the Department of Environment and Water, $192,478,000, and administered items for that department, $33,270,000. I advise again that the government and opposition have agreed to examine expenditure lines for the Department of Environment and Water to ask questions on the review of sand management on metropolitan beaches that has been delegated to the Attorney General by the Deputy Premier. And I declare the proposed payments open for examination once the Attorney's advisors are in place, and then I invite him to introduce anyone new to us.
Questions? While they're settling in.
Absolutely, I think that would be a sterling idea.
Thank you, sir. Number one, for each department and agency reporting to the Minister how many executive appointments have been made since 1 July 2024 and what is the annual salary and total employment costs for each position. Two, for each department and agency reporting to the Minister how many executive positions have been abolished since 1 July 2024 and what was the annual salary and total employment cost for each position. Three, for each department and agency reporting to the Minister what has been the total cost of executive position termination since 1 July 2024. Four, for each department and agency reporting to the Minister, will the Minister provide a breakdown of expenditure and consultants and contractors with a total estimated cost above $10,000 engaged since 1 July 2024, listing their name of the consultant, contractor or service supplier, the method of appointment, the reason for the engagement and the estimated total cost of the work. Five, for each department and agency reporting to the Minister, will the Minister provide an estimate of the total cost to be incurred in 25-26 for consultants and contractors, and for each case in which a consultant or contractor has already been engaged at a total estimated cost above $10,000, the name of the consultant or contractor, the method of appointment, the reasons for the engagement and the total estimated cost. Six, for each department or agency reporting to the Minister how many surplus employees are there in June 2025, and for each surplus employee what is the title or classification of the position and the total annual employment cost. Seven, for each department and agency reporting to the Minister what is the number of executive staff to be cut to meet the government's commitment to reduce spending on the employment of executive staff, and for each position to be cut its classification, total remuneration cost and the date by which the position will be cut. Eight, for each department and agency reporting to the Minister what savings targets have been set for 25-26 and each year of the forward estimates, what is the estimated FTE impacts of these measures. Nine, for each department and agency reporting to the Minister what was the actual FTE count at June 2025 and what is the projected actual FTE count for the end of each year of forward estimates. B, what is the budgeted total employment cost for each year of the forward estimates, and C, how many targeted voluntary separation packages are estimated to be required to meet budget targets over the forward estimates and what is their estimated cost. 10, for each department and agency reporting to the Minister how much is budgeted to be spent on goods and services for 25-26 for each year of the forward estimates. 11, for each department and agency reporting to the Minister how many FTEs are budgeted to provide communication and promotion activities in 25-26 and each year of the forward estimates and what is their estimated employment cost. 12, for each department and agency reporting to the Minister what is the total budgeted cost of government paid advertising including campaigns across all mediums in 25-26. 13, for each department and agency reporting to the Minister, please provide for each individual investing expenditure project administered the name, total estimated expenditure, actual expenditure incurred to June 2024 and budgeted expenditure for 25-26, 26-27 and 27-28. 14, for each grant program or fund the Minister is responsible for, please provide the following information for the 25-26, 26-27 and 27-28 financial years. A, name of the program or fund. B, the purpose of the program or fund. C, budgeted payments into the program or fund. D, budgeted estimates from the budgeted expenditure from the program or fund. And E, details including the value and beneficiary or any commitments already made to be funded from the program or fund. 15, for each department and agency reporting to the Minister. A, is the agency confident that you will meet your expenditure targets in 25-26? Have any budget decisions been made between the delivery of the budget on 5 June 2025 and today that might impact on the numbers presented in the budget papers we're examining today? B, are you expecting any reallocations across your agency's budget lines during 25-26, and if so, what is the nature of the reallocation? 16, for each department and agency reporting to the Minister. A, what South Australian businesses will be used in procurement for your agencies in 25-26? B, what percentage of total procurement spend for your agency does this represent? C, how does this compare to last year? 17, what percentage of your department's budgets have been allocated for the management of remote work infrastructure, including digital tools, cybersecurity and support services? How does it compare with previous years? 18, how many procurements have been undertaken by the department this financial year? How many have been awarded to interstate businesses? How many of those were signed off by the CE? 19, how many contractor invoices were paid by the department directly this financial year? How many and what percentage were paid within 15 days? And how many and what percentage were paid outside of 15 days? And 20, how many and what percentage of staff who undertake procurement activities have undertaken training on participation policies and local industry participants this financial year? Thank you, sir.
You are welcome. I advise that the member for Bragg is asked to be discharged to be replaced by the member for Colton, and I now declare the aforementioned payments open for examination. I call on the attorney again to make a statement if he wishes, or to introduce his advisors, please.
I will take you up on the latter, Chair. With me, I have behind me Darren Corcoran, the Director for AGD Financial Services, Tanya Brooks, the Principal Accountant for AGD, Justin Lay, the Principal Advisor Budgeting, Attorney General's Department. On my far left, next to me, I have Adam Kilvert, Executive Director of Policy and Community. I have Caroline Mealaw, the Chief Executive of the Attorney General's Department. And on my right, I have Andrew Swanson, the Chief Financial Officer of the Attorney General's Department, who, Chair, I'd like to point out is in his 27th year of budget estimates. It is a
quite an
superhero effort, like holy guacamole, Batman. 27 years, and I thought it might be bitumen or gravel, but I'm informed that the gift at a 27th anniversary is sculptures. So I'll be sure that to present Andrew with maybe a homemade sculpture from one of my kids at a later date.
Look forward to that. Anything further to add to your statement, Minister?
You're welcome.
Minister, any further to add to your statement?
Oh, no,
that's your opening statement?
Yep.
Excellent. Member for Colton, do you have an opening statement? Are you the lead speaker? Or?
For the moment.
I'll tell you what, I'll just open it up to questions. Who'd like to ask a question? Member for Colton.
Thank you, sir. And just wanted to start by expressing my gratitude to the government for allowing questions in regards to the beach management review and for.
Chair, if we're going to do a couple of beach management questions, I can talk about the progress, the government's review that's going on at the moment in terms of day-to-day operations. That's not something that I have control over. But maybe if we want to swap the Ben Bruce from the Environment Department just for a moment to help provide answers.
Did I understand from that, Minister, you've got a statement to make? Is that what you were saying? No? Okay.
No statement to make.
No.
Happy to refer to the budget paper and take questions.
Go ahead, Member Cole.
Sorry, sir, I interpreted the most recent comment in the same way you did, that a comment was about to be made in regards to day-to-day operations, which I thought was outside of the scope of the Minister's role.
To clarify, in terms of day-to-day operations, that's outside my role in taking on the area of the review and future.
Well, I can assure you I would never dream of stepping outside of the scope of your responsibility, so I'll ensure that the questions are constrained to the beach management review itself.
Where this is? I'll wait for it.
Very good. So the budget reference being Agency Statements Volume 2, so Budget Paper 4, Volume 2, page 142 with reference to the Adelaide Beach Management Review in the first paragraph below the table. Minister, when will the government release the outcomes or make a decision, pardon me, if that's more specific for you, in terms of future steps and activities to be undertaken on the Adelaide Metropolitan Coastline?
We're actively looking at what's been put forward for the review and the results of testing that's being done.
Minister, why has my community had to wait more than 3 years for the result of a review?
Because we wanted to do this properly, not in any sort of rushed way. And I think I might add that those beaches, the West Beach, Henley Beach area, I think this year have received a record amount of sand to replenish those beaches, more than has happened in any other year before. So the idea that nothing's happening and that there's not sand being replenished, I think it's very important to be very clear that more sand has gone on to those beaches, those sort of central beaches, West Beach, Henley Beach area, than has ever happened before.
Yes, if you step down there, Minister, the beaches are in the worst shape that they ever had. Henley South in particular has seen significant erosion events.
It is just as well the government's putting on record amounts of sand, more than the Liberal government did in any one of their 4 years in government recently.
Have any options been ruled out by the government based on feasibility, cost, environmental damage, or any other reason?
I'm not going to start preempting the results. As I said, they are under active consideration.
Has a suitable sand source, offshore or otherwise, been identified for any long-term dredging program? And if so, when and where? Noting that advice previous to now was that one didn't exist.
I can advise that's exactly why such a in-depth program of testing has occurred.
Yes, Minister, but has any been identified?
As I said, I'm not going to preempt the release of what actions are going to be taken, but it is under active consideration.
But you don't contest that prior to now a significant enough or suitable sand source had been identified?
Well, that's exactly why the most thorough testing of these things, I think, that's ever occurred, has been undertaken as part of this process.
Minister, why was dredging of the West Beach sandbar included in the dredging trial, having not been mentioned previously or consulted with the purpose-built consultation groups or the community more generally?
My advice is, notwithstanding consultants identifying the sand source that the member has mentioned as being extremely suitable, that option to dredge, even for testing, wasn't taken up.
That wasn't the question, Minister. The question was why was the dredging undertaken without prior consultation with the community groups that have been established?
What dredging is the member referring to?
Okay, perhaps if we want to get into semantics,
well, no.
why was the proposed dredging at West Beach considered without any consultation with the purpose-built community consultation groups?
Why did something that didn't happen not happen? Is that the question?
Yes.
All right, because it didn't happen. You're welcome.
Have you or any member of your staff ever communicated with the member for Port Adelaide, the Deputy Premier, in regards to directions or decisions of the review or the review more broadly?
Not since taking on the role of actually undertaking the review. And
why was the responsibility for the beach management review given to you, noting that Minister Scriven is responsible for PIRSA makes decisions on a day-to-day basis in her ministerial responsibilities with scientific-based evidence and research, and also noting the fact that under the portfolio of PIRSA, there's also significant research undertaken in regards to seagrasses and other issues that are directly relevant to the Adelaide metropolitan coastline. Having selected a different minister, there conceivably could have been an argument that it wouldn't have been as seen as being as close to the Deputy Premier as perhaps a decision to hand that responsibility to you.
I don't understand most of what was asked, but in relation to why am I doing it, because I was asked and I'm happy to do so, and I'm a team player. I understand these are foreign concepts to the South Australian Division of the Liberal Party, but that's tend to be how we work in the South Australian Division of the Labor Party.
You are close personal friends with the Deputy Premier, are you not?
Member for Colton. Member for Colton. I mean,
I don't see the funding
the minister can answer this any way he wishes. We're all good friends.
If you've got a budget line for that, I'm happy to have a budget for my friendships. That would be awesome sauce. But if
tucked away there somewhere.
Look, I'll finish by asking again.
I do eat sausage rolls occasionally in the Deputy Premier's office, if that's part of the question.
By again asking on behalf of my community, when will the government make a decision and give certainty to them?
We are looking at this matter as quickly as possible, but also are taking into account as much of the information for long-term solutions as possible.
Okay, do I understand there are no further questions in relation to the Department of Environment and Water?
Well, there are no further answers, I assume, so no.
In that case, Minister, would you like to rearrange your advisors? Where are we going now? Member for Hyson?
For the Attorney General's Department.
Attorney General's Department.
Yeah.
Do you want to give us half a sec?
Yeah, sure.
Yeah. So these guys. Does any member of the committee have a question of the Attorney?
Chair.
Indeed. Member for Hyson.
Thanks
I was
very
hoping
much,
it would
Chair.
be you.
I'm at Budget Paper 4, Volume 1 at page 15. And
So page, what was that?
15.
15.
And so that's the Attorney General's Department Investing Expenditure Summary Table.
This is probably you, isn't it? Yep.
That's at page 15.
Yep, got it.
About halfway down that table, about 0.5 or 6 on the page, the South Australia Forensic Centre.
Yep.
Yep. Now, we see there an estimated completion of June 2031
Yep.
and a total project cost of $362,088,000 and a 25-26 budget of $15,900,000 and a moving further to the right, an estimated result for 24-25, which was 22 million, which is considerably in excess of the budget amount for 24-25 of 14 million. So, and a couple of figures that aren't there. This is a comparator to the questions earlier about works on Sir Samuel Way. We don't see there, but for comparison, last year, the estimated completion date was June 2028. We now see it's June 2031, so a 3-year delay in the estimated completion. And last year, we saw the total project cost reported in the budget papers as 348 million. That's now being reported as 362 million, which is about 14 million of budget blowout for the project. Could the attorney explain reasons, if any, for the delay, and secondly, for the budget blowout?
I will be happy to. I know that the member for Hyson likes to use loaded terms like budget blowout. What I can say is my advice is...
If there's a technical term that I might better use, I'm happy to.
All right. Acquisition of land is a better term to use, and I'll explain why. I'm advised the original budget of 348.9 million excluded land-related costs. During 24-25, additional funding for land of 13.2 million was provided, bringing that total budget to the $362.1 million. So I don't think it is fair to say a budget blowout. It would, of course, be very hard to complete a building project like this without any land. You need to build on the land, so that takes into account the acquisition of for the funding.
That begs the question why the $348 million budget.
Oh, sorry, it's additional
previously.
funding, additional funding for the acquisition of land.
Yeah.
In terms of the completion dates, I think was the first part of the member's question. I'm advised that the revised project completion date will more closely align with the proposed lease period of existing facilities at Divot Place in the city to ensure a more effective transition between the current and the new site. The relocation of the forensic centre will be a very significant process involving, I'm advised, around 320 staff, including the fit out and transfer of very, very finely calibrated machinery and instruments. It reflects also that it is an extraordinarily complex facility. These sorts of things, forensic centres are one of a kind, that you don't build other ones of these in each jurisdiction. And the very, very specific needs in terms of reducing the possibility of contamination, exactly what's needed for, as I say, finely calibrated instruments and machines is exceptionally complicated, but also the closely aligned with the lease period for the existing building.
Yeah, well, that's a helpful answer with respect. And there's no perfect analogies. I've already made some passing reference to the government's hydrogen project being a $593 million project until it wasn't at all. And here we see, perhaps in some ways, an imperfect analogy to the new Women's and Children's Hospital, a more substantial project, but where time and cost, if they're extended, have these effects. That answer perhaps then begs a follow-on that is, we've seen the budget, the total project cost at 348. I think in repeated budgets now, 2 or 3 years. I think that's been the budget amount. Does the change to 362 million, if that's to be explained away by the attorney making what is pretty obvious point that if you're going to decide to build a new building, you're going to need land on which to build that new building. Does that reflect a late a change of approach away from using the existing land on which the existing building is located to renovate or replace a building to a greenfield site? Because my recollection is that it might have been at all times well and truly in the mix that building a new building was an easier, more productive, likely outcome. In which case, who forgot to budget for the land acquisition in the first place?
My advice is Treasury managing the land acquisition.
It's their fault.
No. Portion of this. In terms of putting it on the same site, I don't think we own that site in Divot Place.
No, it's a lease.
It's a government, so it's a lease. And until it was, some more work had been done about what land might cost and the actual needs of where it might go. Because as you say, it is correct that it would much more effective, efficient, and serve the needs of South Australia in a much better way to have a brand new build.
Yeah.
But the initial budget I'm advised was the cost of the building, and then more work needed to be done about where it might be located.
All right, but you'll forgive me. Does that say that Treasury accounted for that additional 14 million until now, and that's sort of now that the delays being sort of set out, it's convenient now to set out that additional cost that we could have found elsewhere in other agencies until now?
Yeah, I'd have to check with Treasury in terms of internal accounting processes, how they represent what that thing's
But that doesn't
might cost,
sound...
or it simply might be when there's more information as to how you're going to do a project to include them. But I'm happy to go and check those.
All right. Well, that doesn't sound like a yes. It certainly doesn't sound like an accounting tool, and so one's left to. And I appreciate glad if the attorney wants to take on notice some aspects of that, but I think the proposition for the time being is that for some years we've had a total project cost of 348 million against an anticipated completion of June 28. And I said this as an analogy to Sam Way because there you've got a significant delay in the completion of the project, and I was flagging that one might anticipate that comes with a project cost increase just through the CPI and general process, whereas in that case the attorneys said no, 11.5 is still the figure. It's 2 years delayed, but 11.5 is still the figure. Here we've got a 3-year delay and we've got a $14 million increase in the total project cost, but the attorneys very quickly and readily saying, oh no, that's because we've just discovered we need to account for the acquisition of land. So leave aside that whole question, the responsibility for whoever's forgotten to account for that until now.
And again, I might just, I'm happy to take that on notice, but the inference initially was it was a budget blowout when I was able to say this, it takes into account land costs, it's, someone's been negligent in forgetting it. I'm happy to take it on notice, but I won't agree with the characterisation of the honourable members.
All right.
Going down at this stage.
And Chair, I just for the committee's point of view, I just make it clear. I'm very glad to associate myself with the characterisation, unless until further advised. It strikes me it's a clear budget blowout, and that without more, the delay in the estimated completion itself would be the obvious explanation for that budget blowout.
Except I've said.
Yeah,
that's
I
not the
appreciate
reason.
that.
That could be true, except for the facts.
Yeah, well,
Yes.
that's good. If
It is, isn't it?
If those. There's two sets of disturbing outcomes here, as far as I can tell. One is that there's a significant cost increase, the result of a significant delay. The other one is that we're told that the cost hasn't changed despite the delay, but we've got an extra element that was heretofore not accounted. Now, either of those two, I think, need to be explained. I appreciate that the attorney's taken that on notice, and I'm sure the committee will be glad for that information, more particularly in due course. As it stands, on the face of the budget papers, at risk of repeating myself, we have a 3-year delay, and we have an increase in the project cost of $14 million. Is there anything else that the attorney might have to say to the committee about the reason for the delay, or is the attorney telling the committee that that's entirely virtuous in that it more appropriately lines up with the lease period for the existing building?
I'm happy to repeat and say that I'm advised that the project completion date will more closely align with the proposed lease period, and also the complexity as traversed before of this sort of facility.
At the risk of being kind of really trite, we've known the lease period at all times, haven't we?
And the revised project completion date more closely aligns with that.
Which we've known at all times.
So that would seem that the governments are making good decisions.
But not
If
until
I
this
sign
year.
that.
So someone's made a bad decision until this year on that analysis.
Again, I don't accept that characterisation.
All right. Well, I just flagged that, as far as I'm concerned, all balls remain sort of somewhat up in the air while the attorney's taken a series of things on notice.
So to be clear again, let me, in terms of the budget that, my advice is that the original budget of 348.9 million, and I'm happy to find out the reasons, and it may well be because there was no decision on the type of location, distance from the city, et cetera, that the facility might end up being built in, which I know some of those factors were under consideration. So additional funding has been provided as more detailed design phase occurs. I don't think there's anything at all unusual in that sort of process.
No, well, it kind of then stands in contrast with the Sam Way kind of scenario where the project cost hasn't changed, even though we've had to delay. Anyway.
Yeah, I think $11 million for renovations to the facade of a heritage-listed building is a very, very different thing to a new state-of-the-art forensic science centre, which again is a different thing to a women's and children's hospital. I think they are obviously all different projects.
All right. Just focus then on the estimated completion.
It might be worth just saying that I know that we're getting into the weeds a little bit in terms of exactly how costs are being counted.
I'm not.
But,
You might be.
But I think it is worth noting and remembering that there has been a decision to invest over $1/3 billion into a new facility. I think this is a very good thing for
Indeed.
South Australia. We've seen in different jurisdictions around the world problems in their the equivalent of their forensic science places, sometimes due to the actual physical nature of the buildings and how samples are contaminated. The government that the member was a part of previously, and Labor governments before that, hadn't seen fit to do this. So, the fact that there is hundreds of millions of dollars being invested into a state-of-the-art forensic science centre, I think is a very good thing.
It's fantastic. And the SA Forensic Centre is a standout example of a centre in urgent need of replacement, and the funds to do exactly that are enormously welcomed. That just puts the spotlight on competence and capacity and actual outcome. And so hence the keen interest in its completion, and what I might presume is the sentiments of South Australians, let alone those experts who do that wonderful work, somewhat disappointed, if not shocked, to see that won't actually happen until 3 years later than what the government's been telling us in the budget papers throughout its term.
It will happen much quicker than any proposal that the former Liberal government had for a new forensic science centre. Much quicker, because there was none. So it's never compared to 2031, which is a much shorter time frame than never ever.
Oh, here we're in directly jousting rejections of characterisations. But after wholeheartedly rejecting
we can look back to
characterisation,
the 2018 to 2021 budgets, and I'm certain there wasn't any provision for tens, let alone hundreds of millions of dollars for a new forensic science centre.
and what we've seen for now several years is a projected completion date of June 2028, which, without more, appears to have simply gone out the window to a new completion date somewhere further off, towards the sunset, if not beyond the horizon.
Infinitely more quicker than any proposal the former Liberal government had. So we can.
Oh.
Yeah,
I'll take that as a comment, Chair. And perhaps then to illustrate the present sort of straitened circumstances, more particularly, I'm turning to page 29 of the same budget paper and volume, and there we see Program 7, the Forensic Science SA performance indicators. And I stress, as the attorney's indicated already, that that we're talking about some of the best people, not only in the state but in the country and the world, doing this work. And we see in the performance indicators that the major indictable DNA cases with this suspect completed within 7 months, that's and it's been the receipt of additional the subject of additional resources having been provided in 2025-26 to deal with demands going forward. We see this really substantial series of drop-offs in performance. So the 23-24 actual was 62%. The target, which has been maintained year to year, remains 75%, but the 24-25 estimated result is at 45%, which is a significant deterioration even on that 23-24 actual result. Is there any explanation the attorney can provide, and have substandard facilities contributed to it, and are more urgent application of additional resources necessary?
My advice in relation to that particular statistic is that the estimated result is mainly due to the impact of changing laboratory practices following a commission of inquiry into DNA analysis in Queensland and upskilling of new staff in this area. The change to laboratory practices now means more biological samples are progressing to full DNA profiling, which results in more complex samples needing to be interpreted and reported. Since 2024, I'm advised 4 new positions in biology were established to address this increase in demand for DNA analysis, and significant training of these new staff members is underway. I'm advised that rejuvenation of the biology workforce will have long-term benefits for forensic science, and of course, as the member pointed out, additional funding on top of what's been provided in previous budgets and mid-year budget reviews through the 25-26 budget will see even more additional scientific staff and administrative support provided to biology to further address the increased workload complexities and eventually aim to decrease the turnaround times for cases being completed. So, and the member would be aware of some of the particularly occurrences in Queensland that have occurred in a commission of inquiry into the handling of DNA analysis in Queensland. So it is making sure that there are changes to practices in South Australia.
And does that answer also account for the even more startlingly dramatic deterioration in performance that we see at the bottom of that table? Illicit drugs cases, preliminary results issued within 2 months, also the subject of additional resources in both the mid-year budget review for 24-25 and in the 25-26 budget. There's a deterioration that's really quite dramatic, from a target of 90% to an estimated result of 20%.
Yeah, and this sort of goes, we were previously talking about the biology section, now to the chemistry section with illicit drug samples. As the notes in the budget papers indicate, that there is an increased workload and also an increase from the increased complexity in the cases. For illicit drug cases, there is now the in early this year, 2025, 3 new positions in chemistry were established to address the growing complexities in these illicit drug cases. It follows ongoing funding that was provided in the 24-25 mid-year budget review. It's expected within approximately 3 months the chemistry part will again be issuing illicit drug preliminary reports within 2 months.
And is the government confident that those additional resources are actually going to resolve that that current low caseload, or is there going to be more necessary to be done? Are you satisfied, Attorney?
We will obviously monitor how the extra resources we're providing improves and impacts on the caseload, the turnaround time, and we have in a couple of budgets and in mid-year budget review progressively increased the resources available, particularly for FTEs, and the fact that we've done that consistently demonstrates that we will monitor and respond as necessary.
What kind of backlog does that actually represent in terms of numbers?
What's that?
What backlog does that represent in terms of numbers?
How do you mean?
Well, it's expressed in terms of percentages in that table.
I don't have figures in terms of raw numbers, but I'm happy to take that on notice.
Thank you. And I see that the attorney doesn't lean on this data as an explanation for the increased project cost of the new centre, despite having said things have changed, including what we've learned. If I might just finish, in terms of what we've seen in Queensland, changed methods, etc., I would have been interested if that was the case, that the centre needs to be somehow, beefed up or altered in terms of its capacities, given what we've learned over time. The attorney hasn't lent on that as an explanation for we've seen, okay, it's a land cost point, but the scope of the centre hasn't changed. And so I was sort of going ahead to saying, is that performance indicator table itself a pretty good argument for saying, all the more reason to get on with the job? Or is it actually a resourcing matter that with appropriate resources applied, new methods, you can deal with it in the current facility, you struggle on until the new one comes along?
My advice is that the impact of the inquiry in Queensland has changed the way that tests have to be done, and that has resulted in some of the figures that we've seen. The inquiry in Queensland was known when work started on looking at a new building, so that's already factored into account.
Yep.
Is my advice.
Right, good. So just to give the attorney the full benefit, there's been a reflection on the fact that does the lease run until June 2031, or does it run 6 months after that to allow sort of moving of equipment or anything like that? Or I'm just...
Again, I don't have the lease details with me here. I'm happy to take that question on notice, though.
All right.
I had some high-level advice I was able to provide, but details I'm going to have to take on notice. That's as the members probably aware, most lease management issues are through Department of Infrastructure and Transport, and I think it's the case in this one, so I'm going to have to go.
But no one's saying that no one's been aware of the term of it, obviously.
How do you mean?
Well, everyone's been aware of the term of the lease the whole time.
I'll have to take that on notice. In terms of the details of the lease.
Yeah, but you're not suggesting that it's somehow come to light that the lease runs until some time that wasn't actually known, and therefore that's now impacting on the estimated completion?
I've given you the advice that I've been provided. I'm happy to go and see if there's more detail.
Yeah, all right. Right, and to be really clear, the attorney has referred wholly and solely to a decision made about the term of the lease as explanation for the estimated completion date of the project changing from June 2028 to June 2031.
No, I think that's... I didn't say wholly and solely anywhere. I think. in
Well, I'm giving you
anything
the
that I've
benefit.
said.
If there's any other reason.
I've asked for an explanation. I've said, this is a factor.
All right. Are there any other factors?
I'm happy to take that on notice, but as I said, certainly factors will include the complexity that we've talked about of this sort of facility. But I'm happy to take on notice if there's anything further I can add. But
Okay.
to try and characterise me saying it was wholly and solely only this, I don't think it's particularly fair,
Well, that's why I've given you the benefit.
and that's why I'm saying this.
And I appreciate you taking that on notice. But
And I appreciate you appreciating it.
for the time being, there is no other reason that the attorney is providing to this committee.
With all projects, there will be a variety of reasons. This is one that I've been advised of.
And it's one that you've
I've
advised the
mentioned
committee
to you, yes.
just now. And the same way, the total project cost, the attorney, and I might just indicate, as I've perhaps already revealed, my surprise that the again, I'll use the words wholly and solely, reason for the total project cost increasing from 348 million to 362 million is acquisition of land that was not previously accounted for. Yeah.
Sorry, I wasn't listening. Can you just say everything you've said again?
Yeah. And so in terms of the total project cost, the attorney has said now in a number of different ways that the whole and sole reason for the total project cost blowing out, to use that word, the term that I've adopted for myself, from 348 to 362 is the acquisition of land that was heretofore not accounted for in the budget line.
I can repeat what my advice is, that the additional funding for land of 13.2 million was provided. That brings the total in the budget from the 348.9 million, add 13.2, and it takes it to 362.1.
Yeah. That's what we see in the budget.
Yes.
But did the attorney just say at the outset there that the acquisition of land was included previously as well?
No, my advice is that the original budget didn't, the original budget excluded land-related costs.
Right. Curious, given what the attorney said about the rather obvious point that you need land in order to
Yes.
build a building.
So that's why it's accounted for as the project develops and there's more information about the types of locations that might be suitable.
So in the future, whenever we talk about a new building...
No. In relation to this,
Yes.
I don't think you can take something in relation to one thing and extend it to everything.
Can't you? Why not?
What's that?
Is it not a common accounting standard or something? So, but somebody's made the call, because this has been much vaunted, and I might say welcomed, and nothing controversial about a lot of what the attorney said about characterising the urgency of the need for this. But we've seen it in the budget year on year on year on year, unchanging project cost.
Hold it, what year on year on year?
Oh, well,
How many-
just to use the last
how many
year.
years does the member think it's been in the budget? Because year on year would take it back to the last government. And
Yeah,
of
the
course,
whole time
as
the-
we've discussed,
the whole time of
they had an
the-
ambition to do nothing with the forensic centre.
I reject that characterisation. The whole
Oh,
time
well-
this government's been in government,
Yep.
year on year on year, I think, there's 3 previous ones, we've had a project cost of $348 million. And my proposition is, are we to have to, when we first see that, really say, well, hang on, does that include the land on which you're going to build the building?
So for any project, if you ask, does that include the land? We can answer if it includes the land. Yeah, sure.
And in this case, it was kind of just going under the radar until now, and now it pops up as, oh, hang on, we're now going to account for the land on which we're going to build the building. So it's not a very reliable project cost if it at all times contemplated a new building, but only just now does it budget for the cost of the land on which to build the new building.
What's the question?
Well, I guess the accounting question is, why now? Why include it in the budget now and not 3
as I
years
say-
ago? And 2 years ago and 1 year ago?
As I say, I'm happy to check with Treasury. This isn't something that I've actively made a decision about how these things are reported. I'm happy to go away and check with Treasury. as I've said before, it is a stark difference to the policy of the former Liberal government
Well,
not to have a new centre.
There's the proposition as it stands, and I'm grateful to the attorney for taking the opportunity to add to that, if you'd like to. I'd move to page 26. Same paper volume. We're now in Legislative and Policy Services, Program 6 of AGD. And you might find it before I do. But my recollection is it was earlier this year the government announced the creation of the new young offender plan, which included a range of things, bail laws, penalties, and focus on youth street gangs. Now, as far as I can see, they don't get mentioned as highlights or targets. Is Legislative and Policy Services doing any work on those matters? And if so, how do we see that sounding in terms of the budget?
I'm happy to answer it. It is a novel way to address budget papers to say, I'm referring you
Yeah.
to this page and I don't see something on this page, therefore I'm asking a question about
Yeah,
it.
appreciate that. Yeah.
But as novel as that may be, I'm happy to answer
All right.
a question. In relation to the work in the young offender plan, certainly Legislative Services have been heavily involved, as the honourable member knows from having been the planning minister responsible for the functions of the Attorney General for,
You should advertise it in the
for a
budget.
number of months.
Nanosecond.
If you included every single thing that Legislative Services do over the course of a year,
Endless.
you'd run up many, many pages of budget papers, but they certainly have been involved.
Has it finished its work on the young offender plan?
No, that is still ongoing. The member be aware that there are a number of elements to that, changes to the law to deal with street gangs that is being finalised, and also
I think they were described as bikie style reforms.
looking at what, and of course they will be, and legislators were involved in this part as well. Looking, could we just add them essentially to the laws that have been extraordinarily successful in disrupting outlaw motorcycle gangs in South Australia?
So has any work commenced on those?
But absolutely, very, very well developed and well progressed work on those. And as the the different structures, the less formal and less rigid hierarchical structures of street gangs have meant that we are looking for a bespoke approach in relation to that, and work is very well developed.
Does the government, does the attorney have a time at which it's expecting Salary to complete its bail law review?
Salary are doing a bail law review, as I'm sure the member appreciates. Salary do a exceptional work at doing very in-depth and complete analysis of issues that they take on board. I don't have a date for that, but part of the youth offender plan is looking at that very small cohort of young people responsible for a disproportionate amount of matters that come before the youth court, and we have previously announced, and we are doing work in relation to discrete work in relation to that small cohort of offenders in relation to bail and sentencing. And it doesn't appear on page 26, but Legislative Services are also necessarily involved in that as well.
And just like the roundtable meeting for the young offender plan that I think was held back in March, AGD involved in that as well?
Well, AGD were the drivers of that.
And are there going to be more of those? Has there been feedback to attendees?
There'll certainly be further consultation, and I think there already has been with organisation and individuals who's attended that as we develop the response, particularly the legislative responses.
Still on 26, we've got a target now. It's actually appearing on the page. the second dot point and the first dash point is among those targets is to assist the passage through Parliament of legislation to criminalise coercive control. When is that legislation going to be implemented?
Yeah, that legislation, all other things being equal, I would expect to pass sometime after the winter break.
Yep.
It's passed the lower house of Parliament. It's now in the Legislative Council. I'd expect it to pass sometime after the winter break. In terms of the actual implementation, when it comes into force,
That's
it
the
will be
question.
significantly after that.
Yeah.
One thing that has certainly been impressed on me is how important the education piece around coercive control is, that just having new laws that criminalise this sort of behaviour are not nearly as effective as when it helps to influence the standards that people accept. Those involved in the area, in the domestic and family violence sector, have talked about a time of up to around 24 months from when the laws are finalised before they come in to operation, to allow that education piece. And it's not just the education piece to make sure that it's well understood that these are the standards that society expects, but it's also making sure that there's a significant lead in time to make sure those who will enforce the law, SAPOL and others, understand what this behaviour is, what to look for, etc. So it's certainly something that I'm not going to say. It's something that was impressed upon me when we have had consultations with those who've been involved in the sector and the groups that represent the sector for many years, is the desire for a long lead in time to make sure the laws are as effective and well understood as possible.
Well, I note, and not to verbal him, but just to make reference to the portfolio responsibility, I think relevantly the Minister for Police, the Treasurer, maybe in the course of estimates, but publicly anyway, has given an indication that the government's not introducing, not implementing those laws until 2028. And I think that was coming from a Minister for Police perspective, and therefore reflecting part of what the attorney said about the need to make it work from the perspective of police. It's nonetheless, the attorney agree, it's a significant, I think the attorney's embracing that.
No, it is significant, and it's certainly from those that have worked in for many years and represent the sector, a very deliberate, very significant lead in time.
Right.
And it's not, it is partly for those who will be enforcing the law to properly understand what it is, but as it has been impressed upon me, an ability to have that education campaign before these laws commence to try and change behaviours and attitudes, knowing that this is what society expects.
And I take it, therefore, from those two or three answers, and I might say I've put it to the Minister for Child Protection in particular, who's on the record back as long ago as 2021 saying these are urgent matters. In terms then of what are a variety of shared responsibilities within government for legislating through to implementation, is that from the attorney's point of view, is the attorney satisfied that the actions necessary to achieve the target are achieved, and that the implementation phase that's subsequent to it, including the timeline to 2028, is about right and necessary and desirable for the best outcome?
Based on those who have much more experience, much more understanding in this area, yes, I am, for the reasons that I've outlined.
I've just turned to page 58 and 59 in the few minutes remaining. Questions in relation to Victims of Crime Fund. And I could run through these fairly quickly, and to the extent the attorney would like to, or it might be more convenient to take on notice, please just let me know. What's the total balance presently of the Victims of Crime Fund?
My advice is, as of the 31st of May this year, $248 million.
How much has been paid out of the Victims of Crime Fund this financial year?
This financial year?
And and how much has been paid into the Victims of Crime Fund this financial year?
I don't think we have a year-to-date figure, but I'm happy to take those on notice. Certainly for some of the last couple of years, the amount that was paid in by way of the Victims of Crime levies was less than the amount that was paid out. But I think in a couple of years we've seen the fund actually increase because of interest that's paid on the accumulated capital account. It should be, although 248 is a substantial amount in the Victims of Crime Fund, it is regularly paying a substantial amount out as one-offs. For example, in the I'm advised that payments from the fund are expected to exceed the revenues into the fund for both 25, 26 and 26, 27 financial years. And part of that is some of the very substantial calls on the fund that happen from time to time. During the course of the previous Liberal government, states, including South Australia, signed up to the National Redress Scheme. I'm advised that we have a further approval of not of what was originally budgeted for, but an extra $135 million for the National Redress Scheme budget from our Victims of Crime Fund. So there is a substantial amount in there now, but there are things that total hundreds of millions of dollars that are outside the normal operation of the fund in recent years as well.
Thank you. And just in the time remaining, questions in relation to the Justice Rehabilitation Fund. How much has been paid out of the JRF this financial year? How much has been paid into the JRF this financial year? And how many programs we funded out of the JRF this financial year? And how many of those will be for youth? And then what's the nature of those programs?
I'm
and
happy
the
to take
average
that on
cost of
notice, the
program?
year-to-date and a list of the programs.
Okay. The allotted time having expired, I declare the examination of the Department for Environment and Water and its administered items on state records complete, but further examination of the proposed payments and administered items for the Attorney General's Department will continue after the break. Member for Davenport.
I move that the sitting of the committee be suspended until